Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Last week, we talked about the scheduling order. Once the complaint has been filed, the parties need to hold a scheduling conference, and from that, prepare a scheduling order. And in that order, there is a timeline for the parties to conduct discovery. What is discovery? We're going to discuss that today. But know this, that in these employment litigation cases, discovery is your weapon. So let's get started. What is discovery? Discovery is when both parties, the plaintiff and the defendant, obtain information from the other side. The goal is the information will help them make their case in court. The requests are made in writing. Depositions is one form of discovery. They can be oral and they can be in written format. Why conduct discovery? To survive any dispositive motion. What do we mean by dispositive motion? At the end of the discovery, the defendant usually files what we call a motion for summary judgment. And they're asking the court to deny the plaintiff his or her case, and they argue that there are no genuine issues of material fact. That's why discovery is important. The goal is to get to trial. There are 4 types of discovery. Now, there are actually more than 4, but these are the 4 that we typically use. Admissions, interrogatories, production of documents, and depositions that I just mentioned. But I want to talk a little bit about admissions. When we talk about admissions, we're actually asking the person to admit to something. Here's a sample of a request for admissions. You have Jane Doe, the plaintiff, whatever corporation, the defendant. And this obviously is an employment discrimination case. Jane Doe has filed a discrimination lawsuit. And what she has asked whatever corporation to admit, number one, that Jane Doe filed a harassment complaint on January 15, 2020. And she also asked them to admit that they increased her workload on January 20th, 2020. You see the connection there? Why is that important? Because it becomes questionable that they would increase her workload only 5 days after she filed a harassment complaint. That is what we call evidence of pretext, evidence of retaliation. So you see the format here. You have the name of the court at the top, the parties' names to the left, you have your body, then you have your signature line at the bottom, pro se, the address, and you always want to serve the other party with the request for admissions, and you will submit a certificate of service. You see at the bottom, I hereby certify that a true and correct copy of plaintiff's request for admissions have been served upon defendant by electronic document transfer on March 7, 2021, and you put the defendant's name and address. As you can see, discovery is a little intense. but it is necessary if you're going to have a chance in winning your case. Next week, we're going to continue with discovery, but we're going to talk about the interrogatories. We'll see you then.